Hello, everyone. My name is Sean. I am the Crypto Smith. I do appreciate you checking back in with me and clicking on this video about XRP and Ripple. Of course, the SEC versus Ripple case. We've been waiting for more than 800 days now, and we're just getting a ruling from Judge Analisa Torres about some certain aspects of the case, right? And we've been expecting these things for a while, and maybe we have some sort of resolution to the case coming soon. Who knows? It could be months longer. We just don't know yet. But in this latest ruling, this is some good news for XRP holders and for Ripple. So what happened yesterday was the U.S. judge issues ruling on SEC versus Ripple lawsuit expert testimonies. So this is where the judge looks at all the expert testimonies and looks at all the motions for each side to exclude these witnesses and their testimonies, right? You know, you could say the SEC says, hey, we don't want this expert witness to testify on behalf of Ripple because it might be very bad for our case. So the judge has to decide, is that valid or is not valid? And then looks at all the witness testimonies and tries to decide which ones are relevant and which ones are not relevant. Now, in this particular case, this is one of what I find funnier expert testimonies that were submitted by the SEC. Now, this expert was going to testify on what the average XRP holder and buyer was thinking when they purchased XRP. So the only issue that came up was that XRP buyer expert hadn't spoken to a single XRP holder. Didn't take him to dinner, didn't get on the phone with them, no deposition, nothing. Didn't talk to a single XRP holder to actually ask them what they were thinking when they purchased XRP. Were they counting on Ripple to work really hard and then grow the value of their XRP tokens? We don't know because they never asked. So the judge threw that one out, said that one's not relevant. Obviously, the expert isn't really an expert in the fact that he doesn't know what the average XRP holder would be thinking, right? He has no expertise in that subject. Also, it was found out that the SEC actually paid a company, I think it was $3 or $4 million, that this expert witness was on payroll for to be witnesses. So the SEC is paying a company who has these expert witnesses so they can say whatever it is they want the SEC to say. That's not a very good look. It's not an independent third party, nothing like that. It is something that is completely connected to the SEC, and therefore it doesn't really look good. But that's not the motion that she granted, or that's not the reason for the motion granted to exclude this expert. It's just the fact that he really wasn't an expert. So let's just get into this a little bit. So the session discussed the relevance of 15 expert testimonies. The motions to preclude expert testimonies have been partly granted, while some statements have been denied. So, you know, a few wins, a few losses, but the big notable one here is that the expert who was going to say what the average XRP holder was thinking when they purchased XRP and that they were expecting profit is now thrown out. So that was the only witness that could testify on the expectation of profit purchasing XRP. So that might be problematic in the case going forward, which is why it's a very big deal. Now, I don't need to read all the legal jargon. So addressing the reasons behind their decision, the court pointed out the legal standard stating the admissibility of expert testimony is governed by Federal Rule of Evidence 702. It indicates the court has excluded the expert testimonies if they have not met any of the requirements mentioned for this particular rule. At the end, the court decided that a few motions made by the SEC and Ripple Labs should be completely denied, while other expert testimonies should be partly excluded. And it goes on to say a little bit about Hinman's speech, where he proclaimed that Ethereum was not a security, basically known as the Ethereum Free Pass speech. And then Gary Gensler also reiterated that Bitcoin was a commodity as well, and therefore not a security. So we've been going back and forth with this for now a couple of years. So Jeremy Hogan says, the SEC has to prove that you had reasonable expectation of profits from Ripple's efforts. And the judge just struck the SEC's only expert witness on that subject. So now, how the heck can the SEC prove reasonable reliance? Who will testify? We don't know. Now, also, really kind of adjacent to this decision by the judge, Let's see. The Ripple versus SEC regulator goes after John Deaton to revoke his amicus status. Here is why. So John Deaton, obviously, he's the attorney who is representing over 70,000 XRP holders, and all of them have testified, or at least written affidavits, on why they purchase XRP, how they use it, how it's a utility for them, how they. A lot of them never even heard of the company Ripple, so how could they be expecting profits on the efforts of Ripple? So he's got all of this down. The judge granted him amicus status earlier on. Of course, the SEC threw a fit. And so recently, the SEC filed a motion to get him thrown out of the case as amicus because he leaked the name, or he said the name of an expert witness, that particular expert witness that was going to testify about what the average XRP holder was thinking when they purchased XRP. Let's see. So the ongoing legal brawl between the United States Securities Exchange Commission and payments firm Ripple Labs is reaching a whole new level with the regulator, which is the SEC, now going after strong supporters of the firm like attorney John Deaton. Deaton has been the most vocal advocate of Ripple since the regulator filed its lawsuit more than 2 years ago, from providing clarity to the community, filing amicus briefs as a friend of the court, which is what amicus basically means. Deaton's role has been prominent. Clearly, the SEC finds his role threatening, obviously. He has 70,000 people who purchase XRP and are all willing to testify about how they felt about it, about whether they knew Ripple or not, about whether they were expecting profits, about the utility of the token that they use. In recent update, it appears that the SEC, through its lawyers, tried to get Judge Torres to ban Deaton from participating in the case, partly because he disclosed the name of their expert witness. That was the expert witness who just got excluded. According to the update, the judge did not assent to this request. She also agreed that the commission's expert witness should not testify about XRP holders, right? That's what we just got done talking about. So obviously you can see this is an important ruling for XRP holders and for Ripple. And maybe, just maybe, this is going to give the SEC pause to think that the case may not go their way. Like they may not get the things that they want to get. That might put that bug in their ear to be, maybe we should be thinking about a settlement. Maybe we should be talking to the other side about what we can do, because clearly they're going to lose on this portion. Now, if they can't prove that XRP holders were expecting Ripple to create some sort of profit for them, then it kind of blows the whole Howey test out of the water. So that's kind of, where we're at. That is going to be it for this update. Hope you guys liked the video. If you did, like and subscribe. I do appreciate you guys and your support for the channel. And with that, we'll see you next time.